Well, hello and welcome. We're going to start chapter 3 today. This will go along course. I'm going to play the PowerPoints in conjunction with my kind of overlay of this lecture. And we're going to talk about inside the criminal law today. And we'll do a few diversions to a few topics that aren't in there, but we'll pretty much stick with the PowerPoint slides. So let's go ahead and jump in on chapter 3. And this should last approximately an hour. You can take a look at those learning objectives overall. This is going to give you an idea of what we're trying to accomplish here in this chapter. But let's talk first about sources of American law. We're going to focus first on the written sources of American law. And at the highest level, this is constitutional law. Now, there's two paths of constitutional law here. By far the most important one is the U.S. Constitution, or what you could call the federal Constitution, which has been in existence and in effect in the United States for over 200 years. Then you have the various state constitutions, and I will refer in here to the North Carolina State Constitution. So the North Carolina State Constitution, of course, is only going to impact the law inside the state of North Carolina, so there can be differences. And the general rule is that the federal constitution is your floor. You can't go below that in regards to rights or changes to criminal law. And your state constitution is usually your ceiling, but we'll see some examples of that as we move on. The second major sources of law is statutory law. And those are going to be, again, kind of on two tiers. The first tier is going to be on the federal level, and those are going to be found in places like the United States Code, or if you were in the military, it would be something like the Uniform Code of Military Justice, or if it was a specialized group of law like the bankruptcy law in the United States, that's going to be found in the Bankruptcy Code. At the same time, in parallel and also in force, each state passes its own statutes. So North Carolina, and for us, we're going to find most of North Carolina's criminal law in Chapter 14 of the North Carolina General Statutes, and that's how it's referred to, NCGS. Now, none of these federal laws can violate the federal constitution, and none of the state laws can violate the state constitution. We also sometimes use the term uniform laws. These are bodies of law very often drafted by important organizations such as the American Bar Association, which attempt to create a standardized body of law which can go across borders. Now, I haven't done a lot of this. There's been some in the criminal law, but there are always, probably more so than in almost any field, possibly excepting property law, unique characteristics to each state's criminal statutory law. Administrative law is law that is made by administrative agencies. Now, administrative agencies were set up really starting in the beginning of the 20th century because the government, federally and eventually the states as well, had gotten so large that Congress and the president, or the governors and the general legislatures, really couldn't operate efficiently and effectively in many areas. So they set up administrative agencies. For example, at the federal level, you have things like the Federal Trade Commission, the FTC. You have the Nuclear Regulatory Commission. And these generally handle very specific areas of the law. There's some criminal parts of this. There's some parts of the criminal law and administrative law, and certainly administrative law can have criminal sanctions, but we don't touch on it very much in this course. It's more very often geared toward business. The final written source of American law, and arguably one of the most important, if not the most important, is case law. Any of the constitutional rules or constitutional parts of different constitutions and any part of the statutes by themselves have to be interpreted. So if you were to say in a law, you cannot commit a violation of basic rights? Well, you have to define what basic rights are. And you might give a list, but that list might say something like privacy. Okay, well, do you create a sub-list from that? Privacy in regards to emails? Well, when a new piece of technology comes along, like Twitter or something, is that included? So very often judge-made laws interpret the other sources of laws, in particular constitutional law, and they create ways in which we can understand and apply the constitutions, federal and state, and statutory, again, federal and state. When they make a decision, we call those decisions, if they're important, precedent, and they tell us how we should interpret those rules in the future. So what are the purposes of criminal law? Well, your book mentions a couple, but I think there's more. First of all, if we look at just simply the legal function, it maintains social order by protecting citizens from criminal harm, or so says your book. It includes harm to both individuals and society in general. So that will mean we can make a law against both murder of an individual and then a general harm to society like a dissemination of pornography. Very often the legislatures, they're federally or state, are reactive, in which they pass laws in response to specific events that occur. So after 9/11, we had the U.S. Patriot Act, and that reshaped some of the criminal law. There are secondary functions of the law. Sometimes these secondary functions are in fact more important than the primary functions. So first of all, it can express public morality. Now this can be both for the good or for the bad. If you think about what went on primarily, but not exclusively, in the American South from about 1865 on to the 1960s and 1970s, for 100 years, we had Jim Crow. So we had segregation. The law wasn't protecting criminals or protecting individuals from criminal behavior. It was defining how we viewed morality. We didn't want, or rather I would say the majority white population, didn't want the mixing of the races. And it really took 100 years of change in both society for America to finally embrace a multiracial society, at least to the level we're willing to embrace it today. We also have to understand that there can be conflicts between different areas of the country. So sometimes these conflicts are very evident. For example, if we use an old example, back in the 1800s, the Mormons, who are the primary religious sect in Utah, practice polygamy, which is multiple wives. The federal government and the majority of the population viewed this as a violation of public morality, and there was a conflict between the Church of the Latter-day Saints, which is Mormonism, and the United States. The result of which was, in this conflict, Utah, in order to be admitted to a state, was really compelled to give up polygamy. It still survives in pockets, particularly out west, but by and large, the law can have a social function like that. It can also have an economic function and a political function. So you can use the criminal law to obtain political means, and you can use the criminal law to establish economic structures. So, for example, the law enshrines the idea of private property and of respect for contract. Okay, classifying criminal law. Now, when we start to look at these, remember these are not necessarily mutually exclusive categories, and again, we'll come back to it. We're going to talk just very briefly about civil law. Civil law is everything else besides what we're mainly talking about here in the law. That is everything other than the criminal law. Now, civil law includes things like divorce. It includes things like property law. It includes things like torts. And most of this is regulating relationships between individuals, sometimes relationships between the government and individuals, but mainly individuals. And typically we don't use the terms here prosecution and defense. We use the term plaintiff, that's the person who's suing, and the person being sued is a defendant, but he's not a defendant in the criminal sense. Civil courts do not decide if someone is guilty of a crime. Civil courts render a decision as to liability. Is the plaintiff, the injured party, going to be successful against the defendant and be awarded damages? And almost always these damages, or remedies as they're called in your book, are monetary. Occasionally you'll see something like an injunction. Now, one of the ways we distinguish a criminal from a civil case is how much evidence, or what we call the burden of proof, has to be presented. In a civil trial, we are looking for a preponderance of the evidence, and this is a very crude way of looking at it. It's not exact, but you can think about it this way to fix it in your mind. At the civil level, you need 51% to 49%. So you can have instances where I can prove something civilly, but then when it goes to the criminal trial, where it's proof beyond a reasonable doubt, I can't establish that. Here's a clear example of that for you. O.J. Simpson was accused of murdering Nicole Brown Simpson, his wife, and Ron Goldman, her waiter, who had come to, I believe, drop off something she'd left at a restaurant. Civilly, the Goldman family and the Brown family sued O.J. Simpson, and they were successful in establishing by a preponderance of the evidence that indeed he did kill them. That made him liable. But in the criminal trial, the state was unable to prove beyond a reasonable doubt that he killed them and therefore be able to impose criminal sanctions. So O.J. Simpson, as far as the civil law is concerned, did those things. As far as the criminal law is concerned, it was not proved because, of course, you start with the presumption of innocence. Okay, second way we can categorize things, and this applies only to the criminal law. We have three broad categories: felonies, misdemeanors, and infractions. Let's talk about felonies first. Felonies are your more serious crimes. Most states, North Carolina is a little bit of an outlier here, but most states, for a felony, the penalty for violating the felony has to be at least 1 year or longer in prison. Now, that will include penalties that are capital offenses or offenses of death. So your book mentions 4 degrees of felony: capital, first, second, third. North Carolina does have some capital offenses. These are offenses punishable by death. These would be first degree murder primarily, a small number of others. But the Supreme Court really has limited capital offenses effectively, and there's a few minor exceptions, to first degree murder. So the capital offenses are almost always first degree murder, so they're kind of a subcategory of that first degree. All right, so North Carolina has first degree felonies, first degree statutory rape, first degree sexual assault, first degree murder. We also have second degree murder. Now, we don't tend to use the term third degree in North Carolina. We've scattered in our general statutes, and again, you'll find those in North Carolina General Statutes, Chapter 14, different felonies, but we also often have a misdemeanor associated with them. So you'll sometimes see first degree burglary, second degree burglary, misdemeanor breaking and entering, or misdemeanor offenses. We don't tend to use the term third degree in North Carolina. Okay, so your felonies are punishable by a year or more in prison, or execution, which is pretty rare. Misdemeanor is the largest of what we think about as crime. I'm going to set infractions aside for a moment. Misdemeanors are very minor events. So an example in North Carolina would be a simple assault. If you, without provocation, reason, or defense, slap someone, that's a simple assault. You didn't break his nose, you didn't break her arm, you didn't stab him, you didn't shoot her. So that's a very minor thing. Still a crime. You're not allowed to touch people. Offensive touching is the standard for simple assault in North Carolina. So your punishment will be confinement in jail. Now, under North Carolina law, pretty much under misdemeanors, your maximum sentence is going to be 180 days. Most states say up to a year. There's a few ways in North Carolina with tacking on things that you possibly could get that up to a year or maybe even 2, but still, almost always it's 6 months maximum in jail, which is institutions run by the counties in North Carolina. We also have infractions, which we don't have to focus too much on. Now, these are separate from felonies and misdemeanors because infractions are very minor things, parking tickets, speeding tickets. They usually call for no incarceration, certainly nothing for more than a year like a felony or up to a year like a misdemeanor. They typically call for a fine. Okay, now we're going to introduce a couple Latin terms here. And one thing about Latin is that the Latin you see in the law is not the best Latin. There was a heavy revision of Latin in the 1800s, late 1800s, in which we kind of figured out better how classical Latin was pronounced. So when we use a Latin term like mala in se or mala prohibita, we're just going to use whatever pronunciation you're comfortable with and I'm comfortable with, not worry too much whether we're getting it absolutely correct. Okay, so the first of these Latin terms is mala in se. Mala in se is an act, and sometimes you can translate that in evil in of itself, or an act which is inherently bad. So mala in se acts are things that you can look at them and you instantaneously know that's a bad thing. And the way I think is easy to look at this is an act that if you saw your neighbor committing it, even if your neighbor was a friend, you would turn them in. You would call the police. So a mala in se act might be a murder or a sexual assault or a violent beating. The other thing is a mala prohibita. Now these are acts that are illegal, but we don't tend to associate with them as much moral judgment. We may not necessarily approve of them, but we're not willing to turn them into the police. So an example might be prostitution or bigamy. Or in North Carolina, if we look at an example, we have a statute called occupying a motel room for immoral purposes. If I knew you went to a motel to kill someone, mala in se, I'd call the police. If I know you went to a motel for immoral purposes, I wouldn't call the police. Still an illegal act. Now again, not an exclusive category. Most mala in se's are going to be felonies, very often serious felonies. Mala prohibitas tend to be less serious, more minor felonies or misdemeanors. So mala in se, mala prohibita. All right, some more Latin. If we look at every crime, so let's take the crime of burglary in North Carolina. And let me just put this aside for a second. If you look at the screen, let's talk about the elements of burglary. First degree burglary in North Carolina. You break, you enter an occupied dwelling at night with intent to commit a felony or larceny therein. So there are 8 different parts, or what we would call elements, of burglary in North Carolina. So taking these all together, we call these the actus risus, or the criminal act. If you don't commit at least those 8 elements, you haven't committed burglary. You might be thinking about committing a burglary. You might say to yourself, "Oh man, you know, there's $1 million in that safe next door. I'm tempted to rob it." But you're just thinking about it. You haven't committed the act. Almost all acts are actus risus, criminal acts are acts of commission. You went and did the thing. Only rarely is a failure to do something, or what is called an omission, a crime. Usually a prerequisite for charging a crime based upon an omission is that there is an underlying duty. Example, you're a parent, you have custody of a child, and you don't feed them, and the child starves. Now, under North Carolina law, that's actually first-degree murder. You didn't actually kill the child. The child died of malnutrition. But by your failure to act, it resulted in the child's death. By omission, you committed first-degree murder. The kind of third fly in the ointment here is attempt. Sometimes you attempt to do something, you don't complete it. So you attempt to rob a house. You break into a house, you try to get in, but you can't get in. You slip or trip, or the owner comes home. You haven't completed the act. You've attempted, so you've taken substantial steps. You broke, you didn't enter. Okay, you had the ability, you had the intent to commit the crime, but you didn't complete it. That's going to meet our requirement of actus reus. Now, one of the things it's going to do is it's generally going to change the exact crime you're charged with. Attempt, in North Carolina and a lot of other states, is usually charged as less than a completed crime. So you'll sometimes see, particularly on TV, it's attempted murder. Okay, well, actual murder, first-degree murder, might be charged possibly with a capital offense. Attempted murder, not necessarily in North Carolina, but in a lot of states, would be charged as a lesser crime. Still going to go to jail for trying to kill someone just because you weren't successful, but you probably won't be executed. All right, the second part of crime is, we've already talked about the actus reus, the physical act, is mens rea. Now, again, it doesn't look that way to our eye. We see MENS, mens, yeah, that makes sense. REA, ray, shouldn't it be RAY? Again, we're dealing with bad Latin. So the shorthand translation of mens rea is the guilty mind. And for many, many crimes, not all crimes, because there's a few alternatives to classic mens rea, you need this guilty mind. And a guilty mind pretty much means that you know you're committing a crime. You do it purposely. Sometimes you do it through negligence or extreme reckless, but if you take murder, which we were talking about before, if you have a gun, you point it at someone, you know it's loaded, you're mad at them, you point it at their head, you pull the trigger, you had the mental state of mind to kill. That's purposeful, knowing. That gives you mens rea. If you look at other things, sometimes you're careless. You might be driving drunk. You did intentionally get in the car when you were drunk. That gives you mens rea there. But if you cross the double yellow line and you hit someone straight on and you kill them, you didn't intend purposely to kill them. So generally mens rea can be interpreted in that so long as you intended some action, you still have a crime, but the intent of the action when you made that decision limits how high or how low we charge you. But we always are looking for intent. Now, with a couple exceptions, and of course, like the law, here's one of them. Strict liability. Sometimes we don't care whether you intended to do something, we just say, did you do it? And this is called a strict liability crime. Serious crimes typically are not strict liability crimes. But things like speeding. You might be driving on the belt line, you might be doing 75 miles an hour, and you just weren't paying attention to the speedometer. You get pulled over by the cop, you can't say, well, I didn't have mens rea. I didn't intend to speed. We say, no, we're going to impart to you liability here, typically for minor crimes, just if you did the physical act, just if you did the actus reus. And we call that a strict liability exception. A final category to address here is accomplice liability. And the way I like to explain this is the liquor store robbery. If you go down with your friend to the liquor store and he says, I'm going to rob the liquor store. And you said, okay, I'll wait out in the car and I'll drive you away. So he goes in the liquor store and he steals the money from the liquor store. You didn't actually go in and commit the robbery, but you assisted him. You were, under the law, an accomplice. And as a result, even though you didn't actually do all the events because someone else you cooperated with did, and you knowingly cooperated with them, then you can be charged. All right, concurrence, which is sometimes we say you have actus reus, or the physical act, mens rea, the mind. Concurrence means you have to have both together. Causation means that the criminal act caused harm, and attendant circumstances are those things that surround the crime. And they can typically make things worse, or they can make things better. So if you did something not with a complete belief, but with a reasonable belief that you were okay, very often that's a mitigating factor. On the other hand, if you did something for an evil or a bad purpose, we'll call that usually an aggravating factor, and that often will increase the penalty, although it doesn't always change the crime. Sometimes we talk about harm, and these are damages that result from a criminal act. We don't always see damages. Sometimes there's just a conspiracy to do something and you don't complete it. Sometimes you haven't actually done all of the elements of the crime you were getting ready to, and it was interrupted. This is called an inchoate, or an incomplete offense. All right, let's talk about some of the defenses under the criminal law. Defenses typically rely upon one of two broad categories, and we're going to look at each one of these categories separately, then we're going to look at some smaller things inside. The first broad category is excuse, and that says, look, I'm just not responsible. And we'll talk about responsibility in 1 second. The second, after excuse, is justification. Justification actually admits that you did something, but says, here's why that's okay. All right, so let's look at excuse first. These apply very often. Remember, we said just briefly a little bit ago that you have the physical act and the mental state. Excuses say you've got the physical act, but you don't have a mental state for some reason. So here are the big ones: infancy, insanity, intoxication, and mistake. Okay, infancy, if you think about this, we tend to think of an infant as someone very, very young. What the law typically does, and we're going to step away from North Carolina for a second, is we say someone between the ages of 1 and 6 is an infant. 6 and most of the time 18 is a juvenile, and then over 18 you're an adult. Now North Carolina has some rules about 16 years old, and there's some felony rules even younger than that. But basically, if you are under 6 years of age, you are classified under the law as an infant. And if you raise that as your defense, and you can prove, well, I was 6, or I was 5 actually, when it happened, then the charges go away. You can't be convicted of the crime. Youthful offenders can't understand the consequences of their actions, so they can't form the guilty mind, the mens rea. Insanity. Now, there's a lot of misconceptions about insanity under the law. First of all, the misconception is it's a very common plea. It's not. It's a very, very rare plea. I'm an attorney, and in the 30-odd years I've practiced law in Wake County, I think I've seen one successful insanity plea where someone, and usually it's a very serious crime, this was a murder charge, pled insanity. And the DA said, no, you're not insane. I want to go to trial. Most of the time, if someone's clearly insane, the DA and the defense can agree upon it, and there is a civil commitment, and it usually lasts as long, if not longer, than the criminal charge. But here there was a fight. There was one time in 30 years where I saw a successful insanity plea. So it's very, very rare. What is insanity? Well, first of all, it is not a medical term. A doctor doesn't say someone is insane. He gives a medical diagnosis, and one of the most common ones for an insanity plea would be schizophrenia, which is a break with reality. So we say that someone who's insane, suffers from one of these medical conditions, doesn't know what their conduct was, doesn't understand the consequences of their actions, or can't control their actions. Different states have different ways in which they measure it. So many states, including North Carolina, use something called the McNaughton rule, which says they're insane because they can't distinguish right from wrong when they did the act. Sometimes there's lack of capacity. Sometimes there's irresistible impulse. You also have to be able to be sane during the trial. So if you were sane when you did something, but you went insane later, and you don't understand the charges filed against you, and you can't cooperate with your lawyer, you can't be tried. You can be held, by the way. Just because you're insane doesn't mean we're letting you go. All right, intoxication. We're going to talk about two types of intoxication here. And again, we're talking about excuse. There's voluntary intoxication and involuntary intoxication. So let's talk about one voluntary. Voluntary intoxication is almost never a successful defense. It says, I went out, got drunk, I did something stupid, I shouldn't be responsible. Well, no, you're responsible because you chose to go out and get drunk. What can be a defense is if you involuntarily ingested or took in a substance which had an intoxicating effect, and then you went and did something. So here's the difference. If if you sit in a bar and drink, go out, lose control of your car, hit a pylon, spin around the road, hit somebody, do damage to them, can you be charged with drunk driving? Sure you can. Can you use a defense of I was voluntarily intoxicated? No. On the other hand, let's suppose you're sitting in a bar and you're drinking just club soda, and someone puts something in your drink. It can be anything. We'll assume it's a roofie or if it's some sort of illicit substance. And you lose muscle control or you lose the ability really to drive a car safely. You don't realize this because this is involuntary. You don't know you ingested the substance. You go out, you get in the car, you get in an accident. Do you have the defense of intoxication? Yes, you do. But the burden is really going to be on you to prove that, by the way. Okay, next defense here is mistake. And there are two types of mistake here, just like there were two types of intoxication. There's mistake of fact and mistake of law. Mistake of fact means that some basic part of this you believed to be true, and that would operate as a defense. So your book says belief in a rape case that sex was consensual. That's kind of hard to see, but let's take another one. Let's suppose that you put down a jacket, a Wake Tech windbreaker, and it was in the back of your chair. And when you left the classroom, when the bell rang, you forgot your jacket. You come back into the room, there's a Wake Tech windbreaker. You say, there's my jacket. You grab your jacket, you go out of the room. Turns out it's not your jacket. And you're stopped in the hallway by Wake Tech police, and they say, that's not your jacket. And you say, well, it's identical to it. I didn't know it was my seatmate's. He took mine, I took his. This was an accident. That's a mistake of fact. That's a reasonable mistake. That'll operate as a defense. Mistake of law means that you did not know the law. Now, this almost never works. There's very rare cases when it can, but basically we expect every citizen to know every law that was published. And as a lawyer for 30 years, I know a lot of the laws, but I'll guarantee you I don't know all the laws. Still not a defense. I can't say, for example, I didn't know that was illegal, even if it's a very minor technical law. We have a law in North Carolina, for example, called gathering pine straw without permission of the landholder. You might not have known that. And if you were raking up some pine straw on somebody else's land because you were going to take it and put it around some bushes at your house, that's actually a criminal act. And you can't say, well, I didn't know that was against the law. Not a defense. All right, now justifications are different. Justifications usually means that you did all the acts, the actus reus, but you're going to fight your mental state. Now, some of the previous ones, the excuses were mental states as well, but these really focus on mental state. The first one, it's an obvious one, is duress. If you're working at a grocery store and someone comes in to rob it and they put a gun at the back of your head and they say, give me the money in the cash register or I'm going to shoot you, you give them the money. Now, did you commit some of the physical acts of a robbery? Did you take money and give it to someone that not intended? Yeah, I sure did. But you were faced with an immediate threat of serious bodily harm. That's duress under the law. That would be a justification defense. You couldn't be charged with the robbery. Self-defense. Okay, this is the legally recognized privilege to protect oneself or one's property. Now, the amount of force you should use in self-defense is proportional to the force or threat you are facing. So if someone comes up and they're obviously unarmed. You're at the beach. So they come up and they're in their bathing suit and they say, I'm going to slap you. And you happen to have a bazooka in your beach bag and you shoot them with the bazooka. Well, that's disproportionate response. You're not going to have self-defense. Not going to have complete self-defense. All right, let's talk a little bit about stand your own ground and duty retreat and the George Zimmerman case, which is mentioned. North Carolina, like a lot of states, is now basically a stand your ground state. If you're faced with an immediate physical threat, you do not have to retreat. Certainly if you're in your home, and this is something in North Carolina called the Castle Doctrine, you don't have to retreat. But it has to be a threat, it has to be a serious threat before you can use violence. You can't simply proactively use violence. You can't say, well, I thought he might get violent, so I shot him first. Necessity is committing a minor act, usually, to prevent a greater one. So someone is in an accident, they're bleeding in front of you. You're in front of a Walgreens, and the Walgreens is closed, but there's some bandages in the front of the Walgreens. Can you break the window, grab the bandages, and bandage up the guy who's bleeding to death? Yes, you can. That's the defense of necessity. Not widely used, but it's there. Entrapment means that you had no intent to commit the act, and you were induced by the police into doing this thing. So the most common one of that is usually prostitution or assignation in North Carolina. That's why undercover police officers who are pretending most often to be prostitutes can't seek out a hotel room, knock on someone's door and say, hey, I'm a prostitute. Do you want to pay me for money? They really have to wait for the person, the John, to come down and solicit them. And then it becomes an act of prostitution, and entrapment would not be a defense. All right, some procedural safeguards we can talk about. Substantive criminal law, procedural criminal law. Substantive criminal law defines what the government will punish. What is illegal? Murder, rape, arson, burglary. Procedural criminal law, which is much more about protecting people's rights, defines the way we enforce those laws. Most of the procedural criminal law is drawn from the Bill of Rights or your state constitution, and they protect individuals from government overreach. Okay, here are the important criminal protections that exist. The Fourth Amendment. This is going to protect you from unreasonable searches and seizures. The Fifth Amendment, which means you can be deprived of life, liberty, or property without due process. It's also the right to remain silent. We'll talk about that some more. The Sixth Amendment gives you the right to a speedy trial, a trial by jury, although you can waive that, and usually is, the right of subpoena, the right to be represented by an attorney. The Eighth Amendment prohibits excessive, although that's not really been defined very well, bails, fines, and again, some debate about this, cruel and unusual punishment. And the 14th Amendment, kind of a catch-all, says everybody is guaranteed due process and equal protection of the law. Okay, so due process is in fact found in both the 5th and 14th Amendments, and it requires that the government act fairly, not arbitrarily. So there's two types of analysis that we apply to due process. We ask, is the law or is the government behavior a violation of procedural due process or substantive due process? Procedural due process means you are carrying out the law in a fair and orderly manner. So let's suppose you pass a law that is punishable by death, and the only people being prosecuted are people who suffer from, who are albinos, who are blind, who are suffering from dwarfism. So albinos, blind, dwarfs, and not to use pejorative terms. And those are the only people being executed. And add another 2 or 3 categories if you like. Only people who are Mormons, only people who are recent immigrants. If those are the only people being prosecuted and executed, that's a violation of procedural due process. The law has to apply to everybody, and if you're not applying it to everybody, then we have an issue. Now, substantive due process means the laws kind of themselves have to be fair. Um, that's a you can't have a, for example, a disproportionate. You can't execute someone for jaywalking. Victims' rights. One of the things that's been kind of rediscovered in the 20th century is that one of the purposes of the criminal law is to protect the victims. So for a long time, victims had very little say in criminal cases. And some states, including North Carolina, have passed victims' rights legislation. So very often, and this includes both federally, victims now have the right to be informed of what's going on, to be heard, to be present and see. Very often, DAs are compelled to communicate with them. All right. Well, that's right about where I wanted to be, about 40 minutes or so. And I hope that was helpful, and we'll move on to chapter 4 coming up.